Hi, guys. It's Kathy. I hope you're doing well. And I hope somebody remembers where we left off yesterday because they shut my computer off. They did. And I started at 4:30 like I was supposed to. I'm barely here. But I made it. Okay, so yesterday we stopped at, I think we had 124 left. But I'm probably wrong. But that's where we're going to go. Going the wrong way. That doesn't look right. No, that's about right. I'm going to start here. 123.27. Let's see if this is it. Let's see if I'm close.
Can I release the witnesses? I don't know. Are we through with witnesses today?
We still have the motion to compel. And
Do you need the witnesses for a motion to compel?
Yes, sir.
Which?
I think if Detective Denmark can stay, everybody else can be released.
The motion to compel, that's in the 0152 case?
Yes, sir.
So just realize what they're saying here. There's all these different cases going on. So this is the custody order hearing, permanent custody order hearing, but there's also all the other cases. So there's not a verdict at the end today, but it's huge at the end, huge. I don't even know what it means. But it's not good.
And I'm just asking because I don't know, what does a witness have to do with whether or not I'm going to require compulsion of discovery?
One of their defenses is attorney-client privilege, and that attorney-client privilege was pertaining to her notebooks was waived when she gave those notebooks to law enforcement as evidence.
Okay. I'll entertain that. Are we through with the evidence in regards to the custody?
I don't have anything further, Your Honor, but I'd like to make an argument.
Mr. Harrington, are you through?
I was briefly going to cross him, but if I can confer with my client a moment, I may not have to.
Okay, you go ahead and consult with her. You don't want to present any evidence other than what you've done with her.
I think you've already articulated the meat of the facts that it's there. I just have some arguments on the issue of what constitutes religious exposure.
But what I'm saying is, in regards to the concept of me reviewing my previous custody order, you're satisfied that all the evidence has been presented?
Yes, sir.
All right.
It wasn't my intention to present any new evidence.
All right.
I released Officer Pratt.
Thank you.
Your Honor, I would have asked you to redirect and then cross on that.
All right. You may proceed.
And I said, Mr. Hetzer, I meant Mr. Kelly, of course.
Sure.
Ms. Hetzer, how many times has a settlement offer been made in this case to you?
What relevance is that?
Well, the second question would give it the relevance.
Okay. I'll entertain the second question.
How many times have those settlement offers been withdrawn less than 12 hours before we come to court?
I don't know about the numbers, how many and how long, but it's always, yes, there's always settlements and then they're withdrawn right before or soon after they're made.
Do you believe y'all can cooperate with each other,
Yes.
even with the history of what's happened in the past?
I mean, if we both try, I think that we can.
That looks like that's you, Fozzie.
What are you asking this court to do with regard to religious
Doesn't
instruction?
matter what she asked this court to do, this court is going to decide what it's going to do. And I'll decide whether or not I accept it. What she wants me to do is not relevant, Mr. Harrington.
He doesn't like
I'm gonna
her.
make my decision based on the facts that are before me.
Yes. Have the children been indoctrinated
Bill.
in any way into the Catholic Church?
I don't feel that they have. They were baptized, and that's the only thing that's happened.
All right. Explain the significance of the First Communion.
First Communion follows First Reconciliation. Those are the two sacraments that usually go together. And after you've had your first confession and your first communion, then you can go to confession and communion at any time at any church in the world, any Catholic church. And it's the way of being reconciled to God and then receiving the body and blood of Christ during Mass.
And upon the objection of Mr. Kelly, what did you do with the scheduled First Communion?
There's been nothing done with it. The children are not scheduled for any sacraments or any classes.
That's all of this witness, John.
Anything else, Mr. Kelly?
Yes, sir. I've made numerous attempts to come to a religious education agreement with you. Is that correct?
We have attempted, but it's been very far from being settled.
Have I presented you with several documents offering a religious education agreement that we've passed back and forth, offering changes back and forth?
You and I have worked on a document back and forth, yes.
What is my objection to in that religious education agreement?
I'm not
Always.
sure what your objection is, but you think that I'm trying to find loopholes, and I feel like you're trying to prevent me from basic Catholic practice. That's the gist of the argument.
Do you believe our children should be taught to critically think about the world around them?
Yes.
Do you think at age 5 and 6 and 7 years old, they have the capacity to make rational and respectful decisions with the intellectual and emotional capacity as far as religion?
I think that they have the ability to make decisions like any other 5 or 6 or 8-year-old Catholic child has the ability to make them.
Your son Gail went through, I'm sorry, were you finished? I didn't mean to step over you. Your son Gail went through First Reconciliation, is that correct?
That's correct.
What was he given by the Catholic Church after that?
Everybody after that entire day long
I got this one for her. Guilt. He was given guilt. A lot of guilt.
so they call it I think they call it a workshop, and they go through and they prepare the children, and it's several hours. And everybody who was there and participated, and even those who didn't participate, like my other child who chose not to do First Reconciliation that day, they all received a goodie bag that had, I think it had some food in it or a wrist bracelet.
Have I expressed to you that I object to giving children sweets and candies as reinforcement for faith?
Yes, but I don't believe that that's what was happening.
Do the children go to get ice cream or sweets after they go to Mass?
We have a tradition of having a rotating schedule of someone who chooses a dessert each weekend, not tied to Mass attendance or Mass participation, or even when they're not with me, they still get to eat the sweets.
What is your objection to my religious education agreement?
There are many, many objections, and I've listed them out for you. Most of them boil down to the fact that your requirements would put a lot of ability for you to bring contempt motions, and they would greatly hamper the ability of me to practice the faith. You wanted me to not mention basic tenets of Christianity, and you wanted me to make sure that they had a signed agreement by anybody who was going to teach them anything, agreeing to your document. It was unrealistic, and it was never going to happen. It would basically prohibit our children from ever being able to participate in religious education.
Do you believe that what you just said is true?
Yes, I do.
One of the fundamental things that I believe should be in that document is that
No, sir, you don't get to tell her what you want.
did
You
I
get to ask a question.
did I ask you that you not to tell our children anything about your faith as actual fact, but your belief?
Yes.
And so you say that you're not going to do that. Is that correct?
We haven't come to that agreement, but yes, that's everything that I'm teaching them are my beliefs, and I present it that way.
And belief is different than truth.
Sometimes.
What age do I think that I expressed to you that I believe is appropriate that the children, I'm sorry, I withdraw. What have I asked for as a condition of sacrament?
You wanted not to let the child to decide, but that you were going to decide that they were ready. That we both had to decide, which meant you were going to decide that they were ready to receive a sacrament. That's what I recall.
That the children are, would it be accurate to say that I want the children to be intelligently and emotionally mature enough to know what decision that they're making for a lifelong faith?
I'm going to object to the question because she's asking him what he thinks.
I mean, Mr. Harrington, I sustain your objection.
I haven't objected to teaching the children about God and Jesus, have I?
I disagree with that.
I disagree. Sorry. In our religious education agreements, back and forth, do I object to teaching them about God and Jesus? And scratch, I withdraw that question. What documents do I state when I created the initial agreement for us to start working with? Is that correct?
That's correct.
What documents did I say would be the foundation of our children's teaching?
There have been several different drafts, and I don't recall, but I know that what I wanted was the Bible and the Catechism, and you wanted some other religious document, which I didn't object to you teaching them whatever you wanted to during your custody time, but you were requiring that I affirm your religious beliefs as true, and I can't do that.
Do you practice cognitive behavioral therapy?
No.
Do you know what cognitive behavioral therapy is?
I know that it's some sort of used in counseling in certain situations.
Are you trying to assert privilege right now, Mrs. Hetzer, because you're committing perjury?
I don't know
No,
what's.
sir. You don't get to tell her she commits perjury, Mr. Kelly.
Okay.
Wait, you're through. You're through questioning. Your cross-examination is terminated. You step down, man. All right, is there anything else before we go into the motion to compel?
I was going to ask him.
All right, come take the stand, Mr. Kelly. If you'll step up in the witness box and raise your right hand.
Here we go, guys.
You solemnly swear or affirm the testimony you're about to give in this matter is the whole truth and nothing but the truth, so help you God.
Yes.
You can have a seat.
I don't know what's about to happen. I don't know. But remember last time, if you don't remember the last time, the last time he was in this box, since he's his own lawyer, he gets to just do a narrative. He doesn't, question himself. And he's pointing at everybody. He's pointing it at her and her and her. And then he's pointing at the lawyer. And then he turns to the judge and he starts pointing at the judge. And the judge dropped the hammer on him. And he's crying and he's yelling and he's so upset. Here we go, guys.
Upon being seated, if you'll state your name and with the benefit of the court reporter, if you will spell it for us.
Joseph Kelly, Josephkelly.
Go ahead, Mr. Harrington.
First, Mr. Kelly, did you have an opportunity to look at your phone and to confirm that the text messages were true and correct?
No, I did not.
What exactly do you maintain is not correct about them?
They're not complete discussions.
Based on
That
what?
sucks.
Which text messages are we talking about? We've got several floating exhibits out there. There's a couple of yours and one or two of his.
I believe 7 was entered.
1 in 4 of yours was not admitted. Is that right, Madam Court Reporter? I don't have them if they weren't admitted.
While I'm looking for plaintiff 4, I want you to re-examine plaintiff 1 and tell me what in there is not.
Everything preceding this.
Well, what are you suggesting is not there?
My offers to her and her ignoring or being, it's not a complete conversation, and without I can't give you a verbatim what's not there. I'm telling you that this discussion is not complete from that day.
What was the other discussion?
It was on the same topic that was leading into this.
Same day?
Yes.
Mr. Harrington, he did get placed up here. Excuse me.
Can you relate what you believe the conversation was prior to the beginning of the text messages on plaintiff's exhibit 1?
I object to responding to a document that I know is not complete without a full recollection.
Well, if you don't recall, that's
I
fine.
don't recall word for word what it was
You
going on.
stand on your position that it's.
I object.
I object. That was my maiden name. So we were the Kelly kids, me and my sisters.
Complete. Is
That
that
it's
right?
complete. Yes, sir.
I will resubmit it, Your Honor. She's testified it is. He's testified he doesn't believe it is, and he doesn't have any evidence.
I'm going to sustain his objection to P1.
Plaintiff's exhibit 4.
Same objection. There's no dates on this document. I couldn't find where this was. There's just times and all the things are cut off. And 10 minutes wasn't enough for me to go through. And I remember asking for these documents that I was asking, hoping that they would be delivered to me.
Do you recognize these?
I recognize some of it, but I can't confirm that you can clearly see that they're all cut off and there's no telling that they're not edited. So no, I don't confirm that is a complete, accurate discussion.
Do you not see that on each page, top line is the same as the bottom line?
Why are the pages inconsistent? Why is there one page is full page and the other page is not full page?
Do you not see that the lines are continuing so they
No.
overlap on each page?
I don't agree that I believe that that's a full and accurate representation of that discussion.
But you have no evidence otherwise?
No, I don't have any evidence otherwise because I haven't had time to thoroughly review.
Did you have a disagreement with Ms. Hetzer, in May, about whether y'all were to meet at the Sonoma Police Department or the sheriff's station.
Yes and no. So the context for that, Mr. Harrington, is that when the judge issued his February final custody order, where he directed us to meet at and the language in the court order stated specifically the law enforcement center in the county, or the county law enforcement center in the receiving parent's county. And Mrs. Hetzer asked me where I wanted to meet. And I told her, how about the Warner Robins Police Department Law Enforcement Center? Her objection to my preference was that is a municipal law enforcement center, and the court order requires us to meet at a county law enforcement facility. So then she gave me two options, the jail or the sheriff's office. I chose the sheriff's office, and that was the standard of where we were meeting.
Sonoma Police Department is not in Houston County.
No, it's in Coweta County.
Did you or did you not agree prior to her getting in the car to drive up here to meet the Sonora Police Department?
Sonoy, yes, sir.
And that would have.
No, I'm sorry. I did not agree. I misunderstood your question. I did not agree to meeting up there beforehand. She, previous to that, she had stated, and I believe it was something to the effect of, I was bringing the children to her early because I was having car issues with my AC. And I was going to meet her at noon a day early because I didn't know that I would be able to have my vehicle back to meet her on Sunday. And we were having a dispute about that. I ended up having to come all the way down here to pick them up. And she said explicitly, no more, quote, new arrangements. And the meeting at the county or the Sonoy Police Department was a new arrangement. So I took her to mean that that was off too. And then so I texted her to confirm, hey, we're meeting at sheriff's office, correct? And she said, no, Sonoy Police Department. And so I said, well, I thought you said no new arrangements. So that's the context there.
You came up with the address for the Sonoma Police Department. That's when
2 weeks earlier, yes.
it is in fact 40 minutes closer to her and to you, correct?
I agree, yes, 100%.
Okay.
I'm not the one that interpreted the court's language that we can't meet at a municipal law enforcement center. She did. She said it has to be, quote, county law enforcement center. She did this previously when she refused to accept that the court's order allowed us to change the 7 p.m. phone call time.
Moving on. Did you disagree where in the parking lot you had to park on the most recent exchange in Coweta County?
2 weeks ago, when conflict had escalated, I didn't feel safe meeting her in an empty parking lot. And the detention side of the building is always empty. There's very rarely anybody there. At the administrative side of the building, there's always law enforcement officers coming and going and coming and going and coming and going. And so on May 29th, or May 29th or June 29th, the 2 weeks prior to this last one, I believe it was May 29th, June 29th, I said, let's meet over on the administrative side of the building. And she promptly agreed. I said, because there's more people over there. She promptly agreed. And then at the last one, I show up at the administrative side of the building like we had done the prior week. And she was on the other side of the building and refused to come over and forced me to go over there, which I did. And I was angry. And she was acting that she's going to interfere with she's going to make me drive all the way down to Perry to get them instead of bringing them over to me.
And then did you tell them, wave your finger at them and tell them to stay there because you already called the sheriff?
Yes, they were dispatching an officer for the domestic dispute.
At the time you did that, had you already collected the children and placed them in your car?
No, I was on the phone with the police, with the dispatcher. And they had dispatched Noonan Police Department to come. And that's why the response was so late. After they had left, the dispatcher, the law or the Noonan Police Department, I called to report that they were interfering with custody, trying to take them out of the county. Once they had left the sheriff's or the jail, Noonan PD no longer had jurisdiction, so they dismissed the call.
Did they in fact keep you from your children?
They were threatening to, yes. They said, if you're not over here in 1 minute, we're taking them back to Perry. So yes.
Is any of that in these exhibits?
Yes, she did say something to that effect. I said, you come over here. She said, no, and so finally I just went over there. Again, I made the compromise to end the escalation and end the conflict. It's about petty control for her. Her objection today or yesterday about that incident, she said that she's not coming over to the administrative side because there's a sign that says you are entering the guard line. And her husband carries a concealed weapon, and she doesn't want him to come into a guard line with a concealed weapon. And that's why she's not coming over there to the other side. She didn't articulate any of this to me. She just said, I'm not coming. I'm not coming. I'm not coming.
She didn't tell you that. That's all just your presumption.
No, she told me that. She told me that yesterday. That was over 2 weeks ago, sir.
And while the children were there and the exchange is taking place, you're on the telephone calling the sheriff's department or the dispatcher to come have their mother arrested in their presence.
No,
You had them in the car, correct?
no, that's not correct. I dialed the non-emergency number from the other side of the building and was on the phone when I came around the building to get the kids, to stop them from leaving.
And you weren't on the phone the whole time directing the sheriff's department to come or to get you somewhere.
No, not the whole time. Once the officer called me back, it was like 2 minutes, once the dispatch, they left maybe 2 minutes into the call, and then the dispatch said, the officer's going to be contacting you. And I said, the incident's already, like, she's already left. And she says, well, the officer will call you. The officer called me. I told him what was happening, that she was threatening to take the kids back. And I just wanted them to come to stop her from taking them back, forcing me to drive 2 hours to pick them up. And he said, well, if they've already left, it's no longer in our jurisdiction. And it sounds like things have de-escalated. So I'm not going to do, he said, I'll give you an incident report, but we're not going to take any further action.
Did you, in fact, with the children in the car, hold your phone to your ear, driving around their car, get their tags so you could tell the officers?
Yes.
And you were still insisting that they go arrest her?
I wasn't insisting. I thought they were coming to, I had already placed the call to the police, and the police were asking me what the tag number and description of the
Let's
vehicle.
go on to something else, Mr. Harrington. I've heard all I need to hear about that incident, and then some.
Mr. Kelly, when you don't get your way, do you frequently threaten to call the law on her or file a petition?
When she's in violation of the court order, or when she's breaking the law, yes, 100% of the time.
And when you come to court, when we get here, you wind up dropping most of it almost every time, don't you?
I had offered to drop everything multiple times, and you had her testify to this earlier, where she said that within 12 hours, I give you guys, okay, look, I give you a window, and I can see that you've read my email 14 times, and I'm tired of being ignored by you. I mean, I'm trying to find path forward, and I went from, I'll settle all of the matters for $1,300, and you don't have to admit guilt. You just can never say another negative thing about me. And she says, no. Then last time, prior to this, I said to her, I said explicitly, Cindy, this is the first time that she and I had a vocal conversation in a year and a half, talking to each other on the phone. And I said, what do you need from me to find resolution? She said, drop the lawsuit. I said, okay. And within 9 minutes, I had drafted a document to send to you. And then immediately after I drafted that document to join in dismissing all of this, She started calling me a liar. It's your fault all of this is going on. And I can't believe you did this to us. And I explicitly told her, I said, Cindy, if you call me a liar one more time and you say this is all my fault one more time, I'm going to withdraw my offer to settle. And she, for the next 30 minutes, continued to berate and belittle me. And I noticed that she didn't bring that conversation.
Mr. Kelly, quite simply, you don't have it your way. You threaten with court, don't you? Yes?
No, that's not true. When I feel she's in violation of the court order, I say, hey, look, every time prior to every one of these motions I've filed, I've sent a good faith email to her. When she doesn't respond, I send it to you saying, hey, here's my intent to file motion for contempt if you guys don't respond within 7 days. And when you don't respond,
It's not
I file.
respond, it's if we don't do what you want. Isn't that correct?
Purge her contempt, yes.
Okay.
Her husband was yelling at me, telling me you're ridiculous. My son went to go get some water. He didn't end the call. He went to go get some water and he was coming back. And when I asked Connor, I said, hey, where's Ozzy? He said, Max took him inside. I said, can you give the phone to Max for a minute, please? Because I'm not going to use my son to pass a message to another adult. Max says, no, I don't want to talk to him. You talk to him or hang up. And so I say, Connor, just give him the phone, please. Connor, Max is yelling, you're being ridiculous. This is absurd. You're being ridiculous. And so finally I said, Connor, can you put me on speaker? And I say, Max, Oscar wasn't done with the phone call. He just went to go get some water. And then Max went in, brought the kid back out, still ranting and raving. And then for the rest of the call, talk to your dad or hang up. If they like had a lull in their speech for 10 seconds, talk to your dad or hang up. Nonstop. No. I've made some bad choices. And every time I make a bad choice, I acknowledge it and I recognize it and I communicate it and I try to move on from that choice. And 100% of the time, I try to move on from those choices. I'm not going to accept a falsehood. I'm not going to accept that lies that she presents. She's
Not only does he not acknowledge it and move on, he litigates it. He has sued everybody.
Still insists that she was not walking towards my vehicle on February 19th. And she still refuses to accept that as the truth. She has convinced herself that I was stalking her, that I was trying to kill her, and all of this, and she's got it convinced.
What does that have to do with the best interest of your children?
What? All of that?
The obsession you have with making her admit that.
I've never asked her to admit that. But I'm not going to let her tell me.
With every other breath, he brings up the car and the mason jars and everything. For years, we've been hearing this.
That I'm the one that did it. That's what I object to.
You understand she hasn't filed one petition against you except this most recent contempt, alleging any problems or micromanaging y'all's relationship in any way.
It's because I don't do the things that she does. If I were doing the things that she does, I guarantee you she would have been filing. I think that dynamic has changed in the last week. Going forward, I certainly hope so. I'm optimistic about it. We've had some really good, healing, healthy conversations the last couple of nights, and I'm looking forward to continuing those.
And what was in the best interest of the children about you telling her that you were no longer going to communicate with her, that anything to do with the children would have to go through me?
Anything that's presently before the court.
No, sir, that's not what you told her, and that's not what your email said, is it?
Are you testifying, Mr. Harrington?
Let's hold on just a minute. Mr. Kelly and Mr. Harrington, court, I can terminate your cross-examination too,
Yes, sir.
and it's terminated. Do you have anything
Oh my
you need
gosh.
to testify
Oh my
that you haven't
gosh.
already testified to?
Yes, sir.
Understanding that Mr. Harrington will have a right to cross-examine you about what you testify, if he hadn't already crossed you on it.
Yes, sir.
Go ahead.
I believe Mr. Harrington was trying to get at my auto response. And
No, sir. I'm talking about facts that relate to your children, your relationship with Ms. Hatzler, what's in the best interest of your children. Mr. Harrington didn't have anything to do with that.
Ms. Hetzer and I have picked up the ball, and we're playing a more positive game now. And I'm just looking forward
Let
to.
me ask you this, Mr. Kelly.
Yes, sir.
I'm supposed to accept that from what I've heard today.
No, sir, you're not. And I don't, I hope that it's my most, you have so much information and you have so much patience and tolerance, and it's a lot. This whole thing is a lot. And I recognize that it's nonstop, but I genuinely feel that the dynamic is completely changed. We've had the first couple of conversations were gross. They started out good, but now we're communicating healthily. And when we recognize that we're reverting back, we stop and then we move on. And this has happened an hour and 18 minutes that we spoke last without conflict. Or the initiation of conflict, and then us moving off of that topic. We found common ground on a lot of the issues, and we are moving forward to finding common ground on the others.
It's just a little too late for the both of them.
My only objection to her position now is that I don't believe my children are ready to make a lifelong decision about religion. And I think we should educate them and teach them that religion is a choice that they should freely choose, not because I impose it or she imposes it, or not because I believe it or she believes it. I want to encourage their own emotional and intellectual growth. I want them to be able to question things. I don't want them to be told that they're not worthy enough if they don't pray a certain way, or if they don't take a cracker from a priest. If they want to learn to believe that and choose to believe that.
I've got all of that.
Okay.
I want to hear, if you got something new, you can tell me.
No, sir, I don't have anything new.
All right, you can step down, unless you got something else you'd like to cross it on. You can step down.
And I'm sorry, for the record, I had nodded my head no, but the court correctly interpreted it.
All right. You ready to go forward with your motion to compel?
I'd like to make arguments on the custody or did you want to wait for arguments after? I don't.
And as I asked, are you ready to go forward with your motion to
Sure.
compel?
Your Honor, yes,
That
sir.
may be indicative of where I want you to go, Mr.
Yes,
Kelly.
yes, sir. I apologize. So my name is Joseph Kelly, and I appear today as a pro se plaintiff in this matter. I'm before the court on a motion to compel discovery responses and for sanctions.
In the 0152 case.
Yes, sir.
All right.
And for sanctions under OCGA 91137, partial summary judgment under 91156. The defendants in this case have completely failed to comply with the most basic obligations of civil discovery. I served them with multiple discovery requests in April, including interrogatories, requests for production, and requests for admissions. In return, I received one untimely, questionably verified, and procedurally invalid response. They asserted only boilerplate objections, refused to answer any individual questions, and did not produce a single document or privilege log. 3 good faith letters under Uniform Superior Court Rule 5.4 went completely unanswered and ignored. Georgia law is clear under OCGA 911, 33, 34, and 36. Discovery responses must be timely, complete, and verified. Under Rule 5.6, objections must be specific, and under 911-26, privilege can't be claimed without a privilege log. And none of these requirements were met. In fact, what defendants have done is engage in a pattern of bad faith and obstruction that's now prejudiced my ability to prosecute this case. Their conduct fits squarely within the sanctions authorized in Stoll versus State Farm, Wimberly versus Karp, and Cook versus Lassiter. Accordingly, I'll ask the court to compel full discovery compliance, to strike their answers, defenses, and counterclaims, and to enter partial summary judgment on the facts deemed admitted. And I appreciate the court's time and attention, and I'm prepared to walk through each issue and citation in detail.
All right, Mr. Herring.
Your Honor, we timely filed responses to requests for admissions. I did tell Mr. Kelly that my paralegal had gone out, asked for more time to answer. He gave me no more time to answer. We have now fully answered all of the questions he's been
Wait a minute.
provided.
Were the requests for admissions timely answered?
They were.
No, sir, not. They were 3 days late, Your Honor.
Well, Mr. Kelly, I'll look at it, but you may not be aware there is a provision in the discovery statute that says that it's not, well, the bottom line of it is it's not 30 days, it's really 33 days because they get 3 extra days because of the conveying of the request or the interrogatories.
Yes, sir, I believe that's true, and I believe that's calculated in that 3-day late. I believe May 9th or April. I believe that I calculated that in my responses. However, that
I can't recall. I've got several of these type cases are dealing with the 33-day rule, and it seems to me, I thought that this fell within the 33 days, but maybe not. I'll check it again, and Marlon will check it, but go ahead, Mr. Herring.
I believe it did comply, Your Honor. We did have one conversation and he was not responsive. He did not wish to work with me because of the sheer volume of the things he asked for. Over the time that we've had to do that, we have now complied and given it all to him, both.
You've answered all the interrogatories? Is that a yes?
We answered each interrogatory and specifically objected when it related to attorney-client privilege, which he repeatedly asked for.
All right, so all of the interrogatories have been responded to.
no, sir.
Mr. Kelly, I want to tell you something. You interrupt me one more time, I have contempt power.
Oh my God.
And you can stay a couple of days in the county jail. Do we have an understanding?
Yes, sir.
I tell you, probably the easiest and the best way is for me to, let's go ahead and file your responses. And then I can review the responses that have been filed. We'll go ahead and file them with the clerk so I can review them and I can look at the sufficiency of them.
Peach court filing, Your Honor.
Sir,
Normal peach court filing.
that's fine.
Okay.
Now, what about this? You earlier, Mr. Kelly, said something about a notebook thing, and that wasn't privileged anymore. What are we talking about there?
She claimed that I broke into her house and law enforcement came in and dusted for fingerprints. And my children told me that she gave them old notebooks to check for fingerprints. And so I want to get the detective in here to testify about what notebooks they were given by her.
But how does that go to the concept she hasn't complied with discovery?
That doesn't, Your Honor. That one of their arguments is attorney-client privilege. And
that's what I'm trying to understand what you're telling me, Mr. Kelly. And I'm trying to explain to you that I'm having difficulty. But the fact that the notebooks, and they got dusted for fingerprints, or you allegedly think they got dusted for fingerprints. What's that got to do with discovery? Your request for discovery from her and or Mr. Rockefeller? I'm listening.
okay, so one of the points of my discovery is her notes from her phone logs in these notebooks. And she has previously she had previously claimed that her notebooks were privileged.
All right.
And
She claimed her notebooks were privileged. Okay, for what reason did she allege they were privileged?
attorney-client privilege or work product, from attorney-client privilege work product. And I believe it was a 0088 case back in August or September when Rockefeller did not respond to my discovery, and you excused his lack of response because he claimed I'd put the wrong number in the case number.
You got to put the right number on the right case, Mr. Kelly.
Well,
That's the reason we number the cases. So you've asked.
I love him.
0152 for these notebooks.
No, yes, sir.
Wonder if he's married.
And
have you supplied the notebooks, Mr. Harrington?
We don't have any notebooks like what he's talking about, Your Honor.
She doesn't have any notebooks.
She's under oath. You have any such notebook?
No.
she just testified that she did, Your Honor.
I thought she did too.
She keeps a notebook every year from all I've known her for 9 years. She writes in notebooks when she's on the phone. She keeps all kinds of journals in there about
No, I wonder if the judge is married.
her menstrual cycle, her fertility. She keeps all these details in notebooks. She just testified to it.
I was under the impression she had notebooks because she alluded that somebody had broken into her house and got the notebooks.
I can put her back on stand, Your Honor. All I can go with what she tells me.
No, sir, I've already heard all I'm going to hear.
Yes, sir.
He doesn't like her. He does not.
And I contend that these notebooks have notes about discussions where they're conspiring to file false reports
Does
with
the
law
police,
enforcement.
does the law enforcement have these notebooks?
All I know is I was told by my sons that
My
mom.
question is, do you have knowledge that the law enforcement has these notebooks?
Yes, upon information and belief.
And that's what this officer's here to testify to?
Yes, sir.
All right, let's bring that officer out.
So, Lori, was it you that said your notebooks are a journal? Okay, let's just say you keep a diary. Let's say somebody keeps a diary. Dear diary, oh, I wonder if this judge is married. Oh. Okay? And you're married or you're in a relationship or whatever. Can the other person subpoena your diary? No. Can they do that? Can they just subpoena your diary?
Officer Denmark, Deputy Denmark, come right over here. If you'll be kind enough when you get into the witness box, just remain standing and
They can. They can. I just looked it up. Not if it has a tiny heart lock, Michael. Not a lock, a little heart lock. Oh my gosh. Guys, remember that. Don't keep a diary.
raise your right hand for me, please. Do you solemnly swear or affirm the testimony you're about to give in this matter is the whole truth and nothing but the truth, so help you God?
Yes, sir.
You can have a seat, give us your name, and upon giving us your name, if you'll be kind enough to spell it for the benefit of the court reporter.
Douglas Denmark, Douglas Denmark.
All right, Mr. Kelly.
Good afternoon, Mr. Denmark. Can you describe what your job is, please?
I'm an investigator with the sheriff's office.
And how long have you been in that position?
About a year and a half.
And when you say you're an investigator, that means somebody reports a crime and you go look for evidence?
That's correct.
At some point in August or September of last year, did Mrs. Hetzer report a crime to you?
She did not report it to me. It was reported to a deputy that worked for the sheriff's office.
Did you investigate that crime?
I did.
And can you describe what took place during your investigation?
We were called to the house to do fingerprints on a safe, windows, and there was one notebook, I believe. I'm not sure, 100% sure. I know there was a notebook I did fingerprints on.
Did you photograph any of this evidence?
I couldn't obtain any. There was one fingerprint on the window that looks like a kid fingerprint, but I was not able to pull it.
I'm sorry, that wasn't my question. Did you photograph any of these evidence that she took, like the notebooks? Did you take a photograph of the notebooks?
I did not.
But she did present to you a notebook for evidence.
There was one that was on the couch, yes.
Okay, I don't have any more questions, Your Honor.
Mr. Harrington.
Did she show you what was in the notebook?
No, sir. I did not look in the notebooks. The only thing I did is fingerprint on the outside of the notebook.
There's one black notebook, that correct?
Don't remember what color it was.
She didn't tell you that it had police reports and things of that nature?
Not that I can remember, no, sir. I deal with so much I can't remember.
All right, so not notebooks plural, one notebook.
I believe it was just one notebook.
Okay, thank you.
Mr. Kelly.
It could have been more than one,
I don't know.
and you don't remember taking pictures, or you did not?
I did not.
He's already testified he didn't take a picture, Mr. Kelly.
Thank you.
Was there any indication from Ms. Hetzer what the notebook pertained to?
I do not remember, Your Honor.
Anything further of Deputy Denmark?
Nothing for me, Your Honor.
Nothing from the plaintiff, Your Honor.
You're free to go, Deputy.
Thank you.
I know what Anthony would write in mine.
Anything else about the motion to compel?
Yes, Your Honor. Mostly just argument.
All right. I'm going to request that the responses.
I'm sorry, I just did think of something, Your Honor. Can I call Mrs. Hetzer, please?
All right, come on up to the stand, Ms. Hetzer, and I'll remind you, you're still under oath.
Yes, sir.
Judge, he interrupted you.
I'd like to take judicial notice of Defense Exhibit 10 from 0088 earlier today.
Do what now?
Defense Exhibit 10 that we presented earlier. I entered it prematurely.
Or you entered it in the 0088 case?
Yes, sir.
You
I
want
did.
me to consider it in the 0152 case?
Yes, sir. That's what I'm.
It'll
judicial
be
notice,
done.
I think is the. When this criminal investigation was going on against me, were you getting inside information from law enforcement or somebody about the investigations?
Which criminal investigation?
Any
What
of
does
them?
that have to do with the motion to compel?
Waiver of privilege, Your Honor?
I've heard nothing that raises a privilege as to this notebook right now.
I believe it's relevant to the motion, Your Honor.
We're not going into it.
All right then.
Are you through with this witness?
If I can't ask her about that conversation, then
You
if I can't question her about that conversation, then yes.
can go back down, unless you got some questions of her, Mr. Harrington.
Well, no, sir, I don't think I
All
can
right. Go back
reopen
down.
without her having spoken.
All right, I hear argument first on the motion to compel.
So discovery violations are the first issue, Your Honor. April 4th or April 9th through April 21st, I submitted all my discovery in that 10-day window. The defense responded one time with boilerplate responses on May 13th, which was but the May 13th response addressed all of the I believe it's 10 or 11 different discovery requests. The law requires that each interrogatory and request for production to be answered separately under oath and with specificity. What I received was a bundled, vague response riddled with global objections, none of which complied with the OCGA.
All right, Mr. Kelly, let me explain something to you. I've asked that Mr. Harrington file the responses. See, technically, the responses don't get filed in the court file until they need to be used. I'm directing him to file those responses so I can make a determination of whether or not they were sufficient, they were properly objected to, etc. So what my point is, I'm not going to be able to make that determination based on your argument. I need to see the actual documents.
So I got these today, and I'm assuming that that's what he's talking about, but I haven't had a chance to look at them. And so today is well beyond the 30-day or 33 days required for that.
Oh, did you just respond to it today?
Yes, sir.
Listen to,
Sorry, I'm sorry. Sorry. I thought you were talking to me.
We have been gathering the information he requested.
the
We have
question was very simple, Mr. Harrington. Did you just respond to him today?
Yes,
Well outside the 30-day period.
yes.
Okay. Go ahead, Mr. Kelly.
Mr. Harrington did file an untimely motion for protective order at like day 40 or day 38 or something like that. But what also happened was he refused to respond to three, I'm sorry, can I just read?
Thanks, Marty. Yay.
Second issue, Your Honor, is the defendant's improper use of boilerplate non-specific objections. They shall be uniform USCR 5.6 state that the objection shall be set forth specifically, timely. Parsons versus First Union Mortgage Company, boilerplate objections are improper. To Wade versus Vance County, general objections without specific grounds are insufficient. Defendants' combined response document were nothing but general objections like unduly burdensome, irrelevant, privileged, yet they contain no itemization or factual basis, and she never asserted privilege in any of that. The ultimately legally deficient, not only untimely, but I made, and this is probably the most important, is that they filed a motion for a protective order, and 9/11/26 requires that any such motion has to be made following a good faith effort to communicate with me, which never happened. I sent 3 good faith letters to them saying, hey, discovery is late, or hey, there's discovery time is running out. And all of them went unanswered until the day it was late. And it wasn't asking for more time. It was just a generic, and I believe I included it in the exhibit in the filing. But it requires a good faith consultation and a good faith, or a certificate of good faith with all discovery related motions. And with his motion for a protective order, he did not submit the required good faith certificate. And the good faith conference has to come before a filing. And he indicated that he's sorry his paralegal's been sick a few days after the, and I was just, as to my argument about the privilege log. Issue concerns defendant's invocation of attorney-client privilege and work product protections without complying with the law and in a manner that should be deemed waived. Georgia law requires that if any party withholds any documents on the basis of privilege, they must serve a privilege log. That is a detailed list identifying the nature of the withheld material so that the other party and the court can evaluate the claim. Defendants have not done so, and that alone waives privilege under OCGA 91126B5, I believe. But even more importantly, the privilege was affirmatively waived when Cindy Hetzer voluntarily shared third parties, including law enforcement, her husband, and a Florida woman named Sherry Renner, who is a disbarred attorney. She gave the notebooks to law enforcement to be fingerprinted for a criminal investigation involving a false allegation of burglary. And that's not a confidential communication with counsel, that's waiver. And without a privilege log and without proper invocation, and after voluntarily disclosing the material, I respectfully submit that the privilege has been waived, both legally and factually, and the court should compel production of the notebooks and any related communications. And finally, Your Honor, I issued or turned to the issue of sanctions. Georgia law gives this court the authority to strike pleadings, defenses, and enter judgment by default when a party willfully refuses to participate in discovery, which is the case here. And if you'll recall, it was the exact same case in 2028 or 2024 with the other case. Despite being served in early April with multiple discovery requests and interrogatories, requests for productions, good faith letters, 3 good faith letters, not a single document was produced, no privilege log. And this is not neglect, it's deliberate obstruction under OCGA 91137B2C. The court has expressed authority to strike pleadings to render default judgment against a non-compliant party. And that's exactly what Georgia courts have upheld in Stoll versus State Farm, Wembley, Clark, and Cook versus Lassiter. And I'm asking the court to strike their answers, all 13 affirmative defenses and their counterclaim. They've not only failed discovery, they've undermined this entire process through delay, deception, and bad faith. And this is the kind of conduct that these sanctions are meant to address. And that's it, Your Honor.
Mr. Harrington, let me make sure I understand. In regards to this notebook, what's the privilege?
A notebook she explains to me that she had was a notebook she kept the police records.
Shenanigans.
Emails from a lawyer, and excuse me.
My question was, what is the privilege?
I don't know that there would be a privilege of what she's
All right,
telling me
that
was in the
notebook
notebook.
needs to be produced.
Yes, sir. My impression was something that she had with Mr. Rockefeller, but
I'm sorry, what now?
my impression had been it's something she's working with Mr. Rockefeller on. She has corrected my misapprehension.
I still didn't quite catch what you said.
I misunderstood. She told me what it is with her note right here. It is not something that was done with Mr. Rockefeller, which I thought it was. It is not. I will produce it.
Mr. Harrington? Okay. You're going to file the other responses so I can make a determination,
Yes, sir. Excuse me.
but
Yeah.
you admit that they were untimely.
They were. I will show that I did try to communicate with him and tell him that the voluminous nature of it.
Well, but
required-
we're talking all
Light
took place
auburn.
in April. And now this is almost the end of July.
Yes,
So we're 60, maybe pushing 90 days late.
yes.
Okay. All right, I'll hear a short argument in regards to the custody issue.
The tiny matter of custody. Finally getting back to that.
Your go, Mr. Harrington.
Your Honor, respectfully, court's made a ruling and we have tried to abide by it. Mr. Kelly seems to have an obsession with having his quote unquote day in court. And then every time we get here, he tells us he just wants everything to go hunky-dory and be fine. He hasn't disputed that notebooks weren't provided for the education. He hasn't disputed that he's requiring notebooks to be read and examined within 10 minutes, that he won't meet and it goes weeks at a time. He agrees to meet in different places for exchange of the children, all of them law enforcement. Then he changes after everybody gets in the car. The long and short of it is Mr. Kelly asserts that he's making good faith efforts to do everything. But if it isn't his way, he tries to batter the plaintiff with endless motions of which the record is full. We have not tried to prolong anything. We have not tried to make endless motions. She sat here and said she understands him having time visitation with the children. We do ask, since it has to be approved by the court, that some more orderly form of educational system, and that's why we liked the Cyber Academy, because someone else sets the curriculum and someone else keeps up with the curriculum to determine that the children are doing it. She testifies that she made the curriculum to meet home school standards and that she could not get sufficient cooperation with Mr. Kelly to do that. I understand that is a disputed fact, but I think it's very clear that Mr. Kelly is a very much a gotta have it my way or no way kind of guy.
You don't think your client's that way at all?
Not as much as Mr. Kelly knows. As my opinion, the court may have different. But his sheer obsession with having his way by all the vast pleadings he's done is evidence enough that he can't cooperate. And that is her concern. She would like to have the visitation stay the same. She said that from the stand. She's not trying to keep the children away from it. It's just every time some very minor thing comes up, the first thing that happens is, if you don't do this, I'm going to file contempt. And I would
Thank you
suggest
so
that the
much,
court has
RW.
turned
Thank you.
down the vast majority of his pleadings since February. Court is aware of that. And we have not troubled the court with all these minor details. These children's best interest cannot be dealt with as long as these folks are butting heads. And I have to suggest, from looking at the sheer number of pleadings, that she has, in fact, backed off since February. And he has not and will not. And although they have discussed things, that the pattern continues, that if he doesn't get his way, he's in court again. We do request that she have the control of the education, that we ease up on having them absolutely have to respond. I mean, he does things like when he gets mad, he won't accept.
He might go. Might go. You know what I'm going to do? Maybe I should make a video with Mr. Kelly's voice and the smiling lawyer's face. For just me and you. We would enjoy that so much, wouldn't we?
Emails. He decides the emails all got to go through the lawyer. Well, what happens when they don't have lawyers anymore?
Well, this is a unique situation. He doesn't have a lawyer. He's got to deal with her lawyer. I mean, you know, I hear what you're saying, Mr. Harrington, but I hear you.
Well, this is not the perfect custody case. I don't suggest.
None of them are.
No, sir.
If they were perfect, I wouldn't be involved.
But if we get to the needs of the children, he admits that in picking up the children, he's threatening her with protective orders and calling the law to arrest her, even after he's already gotten the children.
Well, Mr. Harrington, I'm going to say this about that. I'm convinced that just one of them needs to have the say.
Then I think I'll stop.
But I'm also going to look into whether somebody else besides these two could have the say.
I understand. If I'm beating a dead horse, I'll stop, Your Honor, but
You beating a dead horse.
thank you.
Mr. Kelly?
Yes, Your Honor, it's not tiny little issues. It's not petty little things. We agreed no religion until we were in agreement. Her life has changed. I respect that. Don't have a problem with that. The problem that I have is her faith telling our children they're not good enough as they are, that they have to confess their sins, that they have to pray a certain way, that they have to do all of these things, or else they're going to burn in hell, or else God doesn't have grace over them anymore. And they're too young to be pressured into this concept of, am I good enough? The science and the data shows that children until they're 12 or 13 years old
All right,
cannot.
I don't need a lesson on.
Thank
the
you, Zach.
Catholic
Thank
Church.
you. Thank you.
Mr. I, in good faith, tried to settle my disputes with her directly through email, and she's dismissive. She used to be dismissive. She's
Micah is the best. Micah, you're the best.
not dismissive anymore. She used to be dismissive, ignore me, and I please stop taking the kids to mass every day until the court has decided this issue. No, I can do it. I'm their sole caregiver, so they can come with me. And clearly it's a dispute. And instead of stopping, taking them to mass once a week.
I don't need to hear anything else about Mass, Mr. Kelly. I got you loud and clear.
The judge just gave us a sneak peek at the ending. Did you hear it? Did you hear it?
She chooses microaggressions to try to push my buttons. She spent 1.5 years filing false police reports. I'm doing X, I'm doing Y, I'm doing Z. Whatever she could do to cast shade on me, she would do it. Well, he's walking down the street and he's got his camera. Oh, let's call law enforcement saying he's violating the court order. I'm walking down the street.
You
with
are
my camera
violating.
to prevent her from lying about what I'm doing. If I think I'm coming in proximity to her, I walk 6 miles a day sometimes, and it's typically around our neighborhood. And if I have to pass her house,
Well, you don't pass her house now if you
No,
live
sir, I
in
don't.
Coweta County.
no, sir, I don't.
That's more than 6 miles.
So I recognize some of the microaggressions that I'm guilty of, and she does too, but she's just less likely to admit that she's doing them. In our conversations, she's apologized for some of them. I wish there was more apology, but there's not. But that's where we're at. And I think with time, we're going to get there. We know this has been a wasted year. At least I know it's been a wasted year. I know that all of this angst and all of this has been about us and about me not wanting her, or not to feel like she's controlling and manipulating me. And that's what it's about. And she's the same way. She doesn't want to feel like I'm controlling and manipulating her. And
I haven't seen an indication from either one of you that y'all put these children first. Neither one of you. It's not about y'all. I think I've told y'all that. It's
Yes, sir,
not about y'all. It's about these children. And I've got to decide where to place these children. And between the two of y'all, I got a tough choice.
All right.
And I'll be quite frank with you, both of you. I'm going to look for a different avenue.
What
Neither
does
one of-
that mean? Did you hear him? He's going to look for a different avenue. You know what that means? He's going to look for someone else to make the final decisions permanently for these kids. These two have to go to someone else. Like a guardian ad litem, maybe forever. This is not a temporary hearing. Where's my mouse? They did it to themselves. He didn't this isn't his ruling. This is just what he's saying right now. My God.
Of you have indicated to this court during the pendency of this litigation that y'all got the best interests of these children at heart.
I disagree with that, Your Honor, because 3 weeks
You
ago.
can disagree,
Well,
but
previously, yes, sir. I wish if I can finish my argument or my statement is that Cindy and I have had some really good, healthy movement towards resolution.
well, her perspective of that is when y'all have good conversation, then you put something extra on it.
This is the last 3 days, Your Honor, that I'm talking about.
You know,
And I disagree with that because they're making general broad assertions about things that occurred and I disagree with that.
Sit down,
They
Mr.
haven't
Kelly.
Presented anything that
Sit down.
clarify or that proves that. She presents half of the argument with she presents her perspective, and I don't fault her. We've chosen badly, and we've taken the appropriate steps to move forward. And I just
there was no evidence whatsoever that either one of you has complied with the order that I issued in February saying that I wasn't ordering y'all to go to counseling, but y'all needed to go to counseling. It hadn't happened. Okay. Anything else, Mr. Harrington? You got the final say.
I would have to open evidence to get in what my clients just told me, but I can't, so,
We're not going to open the evidence.
no, I understand.
But y'all check and make sure that all the exhibits that's been admitted are present. And is there any objection from the plaintiff that I take the exhibits with me as opposed to the court reporter so I can have it available to me to make a ruling?
I have no objection.
Mr. Kelly?
I don't even know what that means, but I don't object.
Well, the exhibits are to remain with the court reporter, but I'm asking y'all's permission to let me take them so I don't have to trouble the court reporter and getting them and exchanging them. When I get through with them, I'll give them to the court reporter.
I understand. Yes, sir. I don't object.
I check and make sure all your exhibits are here. Mr. Kelly.
Yes, sir.
And that's it. That would be it. He's going to pull someone else into these two people's lives to control it when it comes to the children because they're both assholes. Now, I'm 1,000% positive. Had I had to deal with this man, I would be like Cindy or worse. I would probably be way, way, way worse than Cindy is with him because he's so I get it. I get how she got here. I get how she's not going to change or back down or be nice now. No, there's no way. There's absolutely no chance she's ever going to just be nice with him because every little thing she says is a battle, is a fight. So why would she, say anything? Because it's all going to end up a battle and a fight. And then her not saying anything becomes a battle and a fight. And then she makes him say something. He makes her say something. And then she lashes out. Yep. Yep. Absolutely, it drives him crazy and it makes him double down, which makes her double down. And now they both thought, they were both positive when they started this whole mess and they got into court. They were both positive that that they were going to win. The judge was going to see that the other person was just crazy and they were going to win. That's all I had for today. Hold on. I'm going to see if I have something. Something. Let's see. We could just watch something for a few more minutes. Oh, I hate this. It's not showing me how long they are. There we go. 14.
Please ensure that you're dressed appropriately for court.
Well, we saw that.
Please, no hats, no bonnets, no scarves, no do-rags.
I did a video of that. Or if if I didn't do a video of them, I'm about to. I think I did. I think I released it yesterday.
The truth shall be God.
Correct.
Thank you. Please tell me your full name.
Randolph.
We haven't seen this.
Jr.
Thank you.
Sometimes she gets bad cases. So I apologize ahead of time. I didn't. I just looked for it. I had a short of it, but I can't find it. It's somewhere in there. I have too many. So sometimes she gets bad cases. So I apologize ahead of time if the next, I don't know, 10, 15 minutes has a bad case in it because I didn't watch this yet.
The court shows the defendant appears by video from the Elkhart County Correctional Facility and also by Attorney Teresa Heeman, who's here in open court. State of Indiana appears by DPA Smai Hassan. And I show that we are set today for a probation violation, community corrections violation, and a change of plea hearing in 2 other cases. Ms. Heeman.
That's all correct, Your Honor. I believe this matter is going to resolve in a plea agreement, but we're not there yet. I had a tablet Securus visit set for last Wednesday, and Mr. Warren didn't appear. So then we set it up on kiosk in hoping that that would work, but he did not appear on Friday for that meeting either. He has had a chance to talk to our jail liaisons and review my emails back and forth, but he has a particular question that I think he wants only me to answer, and I've answered it by email, but I think he needs me to come in person to answer it.
No.
That's going to take a little time because he doesn't come to his Securus visits. So I don't know any other way except in person. So I'm asking for a little bit more time. And really, Your Honor, I'm booked up for the next 2 weeks.
My next availability is 3
Maybe.
weeks.
I mean, I just have a quick question about the plea bargain. Actually, you might not even have to come in.
Well, we don't have a signed plea, so
Okay.
we'll definitely talk, Mr. Warren, and I think I'll just come see you. It's just been hasn't worked out on Securus.
I just need a word removed because you said on the 415 that she would accept the 6 months only, but you just got to retype the plea bargain and make it say that.
Yeah, I'm not going to do that, and that's why we're talking. 1 year means 6 months with good time credit. So, and I sent you that email, and both liaisons.
But the executed word has to be removed for.
Okay, well, we'll talk. We'll talk.
Okay, Mr. Warren, I don't know anything about this, and that's fine. Ms. Heeman thinks it might be better for her just to sit down and talk with you in person.
All right.
We have
Mrs.
to
Sun?
follow the legal requirements of a
So-
plea bargain.
Okay. Mrs. Sun, is there any objection? No, Your Honor. The court will show on motion of the defendant and without objection by the state, these causes of action are continued to August 4th.
I'm in trial that day in circuit court, August 4th.
Okay,
Doesn't make sense. Yeah, it does.
that's a
right.
Monday.
That's right.
So until August 11th
Yes, please.
at 1:30 p.m. The
Yes,
court
please.
shows that the delay is chargeable to the defendant for purposes of criminal rule 4.
Thank you, Your Honor.
All right, thank you.
Randolph, I'll come
So-
see. I'll come see you.
The next court date is what?
August 11th.
Okay, thank you.
Thank you.
Thank you, Your Honor.
Wesley Ivory.
You're fine. Right there. Stay there. That's fine.
This is State of Indiana versus Wesley Ivory, cause numbers 20D01-1606F325 and 20D01 2504F6417. Sir, raise your right hand to be sworn. Do you swear or affirm under the pains and penalties of perjury the testimony that you provide to this court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. Please tell me your full name.
Wesley Ivory.
Thank you. The court shows that the defendant appears by video from the Elkhart County Correctional Facility and also by Attorney Teresa Heeman, who's here in open court. State of Indiana appears by DPA Smai Hassan. I show that we are set today for further proceedings on a violation of probation matter and a change of plea hearing. And I did see that a plea agreement has been filed on the defendant's behalf. Ms. Heeman, is that what we're doing?
It is, Your Honor. We do also have an agreed recommendation as far as the violation matter.
Okay, so we'll get to that here in just a moment. As far as the plea agreement is concerned, Mr. Ivory, the plea agreement indicates that you are pleading guilty to intimidation as a level 6 felony. Is that correct?
Yes.
Sir, the terms of your plea agreement state that you will be sentenced to 1 year at the jail. However, that will be suspended on 1 year of probation. As a term of probation, you are to seek either anger or mental health evaluation. Okay, the reason why I'm hesitating on that, I don't know if the victim of the intimidation is the same alleged victim of the domestic battery charge.
They are.
Okay.
And she's here.
I can see that. So anger management is not appropriate in cases involving allegations of domestic violence. It's not evidence-based because anger is one of those things that's often missing. You know, we talk about power and control and some of those concerning dynamics. And I don't like being locked into either or.
Your Honor, we put it that way, I think, in order to leave it up to the court, essentially. So
And
if you want to strike the word anger, we can.
And I just would hate to see a situation where he is doing that and then maybe having to take additional programming on top of that. I would prefer that it just be whatever targeted treatment probation thinks will most benefit him. Mr. Ivory, we all have the same goal here. The goal is that you get to whatever programming makes the most sense for you. And I often leave that up to probation's discretion because they've changed their practices in that they meet with probationers and develop a case management plan based upon what your individual needs are. So I would feel more comfortable if your plea agreement didn't spell out what that exact programming is. Does that make sense?
Yes.
Do you have any issues or concerns if we remove the specific programming that's mentioned in your plea agreement and just leave it up to probation?
No, as long as we can get the ball rolling.
Understood. Ms. Hassan, is the state in agreement with that also? Okay. All right. And all of the other terms are left to the court's discretion. What that means, Mr. Ivory, is that the court can order that you have no
Give me
contact with
jail.
the victim of this offense. I can also order that you pay a public defender reimbursement fee in addition to the mandatory court costs, but only if you have the financial ability to pay that extra cost. Mr. Ivory, I don't know anything about the specifics of this case. I'm just telling you generally the terms that the court can put in place in its discretion. Do you have any questions about that?
No.
And that case will be served consecutively with any backup time for the probation violation matter. Ms. Heeman, you said there was an agreed recommendation.
Yes, Your Honor, that is that he would be revoked from probation and have an executed sentence on community corrections as the agreed sanction. And I did do a check of his credit days, and we would ask that those be applied. They're essentially the same anyhow. It's 100 days.
Okay.
He might have one extra day credit actually in the violation matter. So it's actually, I think, 101 on the violation if we give all the credit from April 6th of the new arrest to the old case.
Okay. So Mr. Ivory, there's an agreed.
I'm still remembering the last guy we saw with her. Wanted to go pro se because she won't listen to him.
Recommendation asking the court to revoke your placement on probation and order that you serve any remaining time on community corrections. Is that how you understand the agreed recommendation?
Yes.
Mr. Ivory, I will hear arguments as to why that would.
This is a new prosecutor too. I mean, I don't know. I said that wrong. We have not seen this prosecutor before. Usually it's the blonde-haired girl with the really super shiny hair.
Be the appropriate outcome in your case. If I agree with that recommendation, then I will do what I'm being asked to do. However, if I do not agree with that recommendation, do you understand that I can order that you serve the balance of that sentence through or at the Department of Correction?
Yes.
Regardless of how you serve that sentence, again, these sentences will have to be served consecutively or one after another. Do you understand that?
Yes.
Sir, in looking further through your written plea agreement, I see that there are initials that appear in the numbered paragraphs in the defendant's right section. There's also a signature at the end of the plea agreement. Are those your initials and is that your signature?
Yes.
Before you initialed those paragraphs and signed that document, did you read through it carefully?
Yes.
Did you also review the plea agreement with Ms. Heeman?
Yes.
Did you understand the rights in the defendant's right section?
Yes.
And do you understand the plea agreement itself?
Yes.
Sir, before the court can accept a plea of guilty from you, I need to ask you more questions and hear some evidence. If you do not understand the questions that I ask or the words that I use, please let me know, and I will explain them to you more fully. You may also have a private conversation with Ms. Heeman at any point during these proceedings. However, if you need to have that private conversation with her, you need to let me know that so that we can pause and try to make arrangements for you to speak with her privately. Do you understand that?
Yes.
Sir, have you ever been treated for any mental illnesses, or to your knowledge, do you now suffer from any mental or emotional disability?
No.
Prior to appearing in court today, did you consume any alcohol, drugs, or medications?
No.
Do you believe that you are thinking clearly today and that you understand these proceedings so far?
Yes.
All right, Mr. Ivory, I will now advise you that you have the right to a public and speedy trial by jury. You have the right to face all witnesses against you and to see, hear, question, and cross-examine these witnesses. You have the right to require witnesses to be present at any hearing or trial and to testify on your behalf, and the court will assist you in this right by issuing subpoenas for such witnesses. The state of Indiana must prove beyond a reasonable doubt that you committed the offense charged before you can be found guilty. You cannot be forced to make any statement or to testify against yourself at any hearing or trial. Mr. Ivory, do you understand the rights that I just explained to you?
Yes.
Do you understand that by pleading guilty that you are waiving or giving up all of these rights?
Yes, I do.
Do you understand that if you were found guilty, or if you had a trial and you were found guilty, that you would have the right to appeal your conviction to the Indiana Court of Appeals or the Indiana Supreme Court?
Yes.
Do you understand that by pleading guilty that you are giving up your right to appeal your conviction?
Yes.
Mr. Ivory, I'm now going to look at paragraph number 20 in the defendant's right section of your plea agreement, which is a paragraph that you have initialed. And in that paragraph, it explains to you that by pleading guilty under these plea terms, that you are waiving or giving up your right to appeal your sentence. Do you understand that you are doing that?
Yes.
Sir, you have the right to be represented by an attorney during all stages of these proceedings. That means if you wanted to go to trial in this case, Ms. Heeman would represent you at that trial. If you were convicted at that trial and you wanted to appeal your conviction, I will appoint appellate counsel to pursue that appeal on your behalf. Do you understand that?
Yes.
And again, Mr. Ivory, you are pleading guilty to intimidation as a level 6 felony. A level 6 felony is punishable by a penalty range between 180 days and 2 years and 180 days of incarceration. There is also a maximum fine of $10,000. Have you reviewed this charge with Ms. Heeman?
Yes.
And did Ms. Heeman explain to you what the state would have to prove in order to convict you?
Yes.
Ms. Heeman, does your client waive the formal reading of the charging information and statute?
Yes, Your Honor.
Mr. Ivory, do you understand what the state would have to prove in order to convict you?
Yes.
Do you also understand the possible penalty that you face?
Yes.
Do you understand that by pleading guilty that you will be judged guilty and sentenced without any trial?
Yes.
Do you understand that if the court accepts your plea agreement, that I will sentence you according to the terms of the plea agreement?
Yes.
Do you understand that your plea of guilty may cause harsher sentences for any crimes that you might commit in the future?
Yes.
Mr. Ivory, other than the cases that are here in court today, are there any other cases for which you are out on bond, parole, probation, or under a withheld or suspended sentence?
No.
Sir, do you understand that one of the terms and conditions of your placement on probation is that you cannot commit any new criminal offenses?
Yes.
Do you understand that by committing a criminal offense while you were on probation means that you are also admitting that you violated your placement on probation?
Yes.
And Mr. Ivory, according to your plea agreement, you are a citizen of the United States, correct?
Yes.
Sir, has anybody promised you anything to get you to plead guilty other than what is in the plea agreement?
No.
Has anybody forced or threatened you into pleading guilty?
No.
Are you pleading guilty today because it is your choice to do so?
Yes.
And with everything that we've discussed today, do you still want to plead guilty pursuant to your plea agreement?
Yes.
Thank you. Factual basis, please, Ms. Heeman.
Thank you, Your Honor. Wesley, look back, please, to April 6, 2025. On that date, were you present here in Elkhart County, state of Indiana?
Yes.
And on that date and in that place, did you communicate a threat to unlawfully injure Candace Chansey with the intent that Candace Chansey be placed in fear that the threat will be carried out?
Okay.
And that threat was to
Whew. I was ready if it was something terrible to turn it off real quick.
commit a forcible felony, namely a murder. Is that all correct?
I mean,
That's what it says. But
murder
yes.
is terrible.
Yes,
Yes.
it's correct, though.
Yes. It's not
Yeah.
correct to what I've said, but that's what's on paper.
Well, are you admitting that you made a threat to
Yes,
Candace?
I made a threat. Yes. Yes.
And when you made that threat, you intended that she believe you and fear that that threat would be carried out, right?
Yes. Not for murder though.
Okay, and was it for a forcible felony?
No.
To hurt
No.
her? To hurt? You're blowing your plea if you don't make this
Oh.
factual basis.
Yes. 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 Yes.
So was it for a forcible felony, albeit not murder?
Yes.
And was that intent, that threat that you intended to hurt her?
Yes.
Nothing further on that.
She's not going to take it. Is she going to take it?
Mrs. Hassan,
I don't have any additional questions.
give me just a moment here.
I could be a little more specific if you wanted me to, Your Honor.
I think you're going to have to, Ms. Heeman.
Yep, she's not going to take it.
Affidavit.
I'm just pulling that up right now, so go ahead.
Shall I?
Ma'am, please stop. Go sit down. Stop.
Taser. Taser.
Should I go forward, Your Honor?
Yes.
So Wesley, I'm reviewing the probable cause affidavit, which is the report that got filed with the court about what happened. And in that, it says that Candace said that you had at that time threatened to throw her down the stairs and to cut her head off. Does that sound a little more familiar to you?
No, it does not.
So do you think that it's possible that you said those things in the heat of the moment and you don't have a recollection of them now?
I've never said that to any woman before.
All right. No
That's
plea.
fine. We're just going to set the case for trial.
Saw
All right,
that
Ms.
coming.
Heeman, about when do you think would be an appropriate time to do that?
Gosh, Judge, I would say probably in the normal course of settings. I don't think we need a really quick one, but.
I mean, if I've said this, is there any way that I could be out so I can be with my children and work?
That's not how it works.
No, sir, we're setting the case for trial. Ms. Heeman, I'm looking at October 14th.
Did you say October 14th, Your Honor?
Yes.
Yes, please.
Wow. Oh my God.
Mrs. Hassan? Is that acceptable to the state?
It is, Your Honor.
All right, the court will set this cause of action for a trial by jury on October 14, 2025 at 8:30 a.m. The court will set aside 2 days to try the matters at issue. I will also set a final pretrial conference, and I will do that on September 15, 2025 at 1:30 p.m. Mr. Ivory, do you acknowledge or understand that I've set your case for a trial by jury on October 14, 2025 at 8:30 a.m.?
Yes.
And Mr. Ivory, do you acknowledge or understand that if you are voluntarily absent from that trial, which will include a refusal to be transported to the courthouse for that trial, means that we will go forward without you?
Yes.
All right, and we will set the probation violation cause of action for tracking purposes on those same dates. And we will see you on September 15th. Ms. Heeman, anything else?
No, Your Honor, thank
Ms.
you.
Heeman, the alleged victim is raising her hand in the audience. I'm not going to hear further testimony from her at this point in time.
I will leave you my phone number and.
I want to hear.
Okay.
Go up with our
Anything
investigation.
further, Ms. Hassan? All right, thank you. That concludes the proceedings.
I'll come see you, Wesley, or I'll do a.
So I'll be here until September the 25th or whatever.
Unless,
Until the trial on October 14th.
I don't know if there's a no bond hold in the violation.
I'm sure that there is. It was transferred from circuit.
So I'm here till October the 14th, you're saying?
At least that. I don't know what's going to ultimately happen with the trial, but yep. All right, thank you.
Michael Blasingame.
Why'd you do that?
I'm listening to see if that lady says something loud enough
This
for
is
us to
cause
hear.
number 20-01,
No.
1811F.
No, 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 no. Oh boy. I wonder what she's going to say. Is she going to say, yeah, he said that? Or, oh no, he didn't say that. That was all a big misunderstanding. It was a joke. We were roughhousing. We were play acting, and those were the words that he read. I wonder what she would say. I'm not going to know in October. Oh, in October, she'll be in her new courtroom. It's almost done being built. All right, guys. Thank you so much for watching Mr. Kelly with me. Just no, just hit me during this trial. Whoever Judge Crawford appoints as the one who makes the decision, that person is going to be sued for the next 9 years. That person is going to be in court for the next 9 years getting sued over and over and over again. And I keep forgetting to say something at the end because I don't think about it much. But Casey, I hope you have a shitty day. Bye, guys.
Got these life echoes, digital dreams. Through the screen, her blue eyes gleam. Wicked humor, sharp as a knife. Her stream sparks electric light. Late night when the world sleeps, she's the friend that always keeps. Giggles roll like thunder loud. She stands out in any crowd. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor, dark and twisted charm.